even if elections are conducted under the Elections Act, the elections must meet the principles of the Constitution, because simply in constitutional law, every statute must meet the master and expectation of the Constitution. So that even if you come to challenge an election under the Elections Act, if somebody introduces a constitutional element to the election, the Supreme Court can assume jurisdiction as a matter of right under Article 163, Sub-Article 4A. Number two, we grappled with the question of the burden and standard of proof in elections. You know that in the law of evidence, burden is different from standard. Who has the burden to prove, and what is the threshold of the proof? And we settled this in a lot of cases. Number three, we settled the question of timelines under the Constitution. You know that the Supreme Court in the presidential election petition the petition must be filed, heard, and determined within 14 days. We think that period is short, but in the last 4 election petitions, we have somehow managed to settle it. So, for example, we deliver the short judgment on the 14th day, and then 21 days later, we deliver a long judgment. And so if you look at the Uhuru Kenyatta petition, all the Raila Odinga petitions, 2013, 2017, 2022, we have addressed this question. We have also addressed the role of IEBC and the role of the courts in determining disputes. And we have said IEBC should settle some of the smaller disputes before they come to court. Otherwise, all the courts will no longer be able to work during the election period, because all the disputes will come to court. But IEBC has a duty under the Constitution to resolve some of the smaller disputes. And that is why now they have an IEBC dispute resolution committee that settles petty issues that don't have to come to court. We have also settled the question of conduct of repeat elections. In 2017, the August election was repeated in October, and we gave the parameters for doing so. We also determined the appellate mechanism of the different electoral seats, and we have said MCAs can start at the magistrate court, and then they come to the High Court, and then they come to the Court of Appeal, and then they stop. When the Supreme Court now starts handling disputes I used to go to the Runyenjes court here. So imagine if the MCA for Runyenjes has a dispute, and then they come through the entire court system to the Supreme Court to tell us what if the Court of Appeal has settled the matter. So we are saying we also don't want that, because of the legal process, it begins from Runyenjes to Embu, to the Court of Appeal in Nyeri, to the Supreme Court in Nairobi, and the Supreme Court delivers a judgment a few months before the next election. Because that's what used to happen before. Now we have said, let it stop at the Court of Appeal. We have also resolved the issue of pre-election disputes and exertion of available dispute mechanisms. We have also settled the place of scrutiny of votes. You know, in Kenyan elections, every time, like in the Embu Hall, when results are being tallied, there's always a dispute. And so when you come to court on a petition, we have settled the procedure, the process, and the content of the scrutiny of votes. We have also determined what is the role of the chairperson of the IEBC vis-a-vis IEBC, qua IEBC. So we settled whether the late Wafula Chebukati could do some things as chairman, or he could do some things as the commission. And again, that's an important point.